Watching that play out, they're making very substantial settlements. And Leo's involved, and Pam Bondi's involved. We've launched. You know, we're getting hundreds of millions of dollars in settlements, Pam. And Leo called me up, sir, you can do better than that. I said, what am I going to do? I'm going to get one where he really likes it. But he always said, everyone else says, that's amazing. Except for Leo. He says, sir, could have got more. Oh, good. Thanks, Leo. But we've launched sweeping civil rights and Title IX investigation. Virtually nothing. And much lesser things that take place in the home. They won't cry. You know, they'll do anything they can to find something. If a man has to fight with the wife, they say this was a crime. See? So now I can't blame 100%.
Jeffries and Schumer are not endorsing Mamdani right now.
I mean, for me, this is not about feelings or hurt feelings. It's about the fact that we have a Democratic nominee. Are we a party that rallies behind our nominee or not? If an individual doesn't want to support the party's nominee now, it complicates their ability to ask voters to support any nominee later. For the good of the party, we must put our differences aside.
Has to do with population decline. So if you think about what happened to Detroit when this isn't necessarily population decline. Detroit lost residents because industry improved. But then you see poverty, crime, and other problems start to emerge. I'm wondering how much of what Trump is doing with sending the National Guard is to try and create a status, like a foundation of stability. Because in the next 10 years, it is going to get increasingly worse.
Negative net approval rating. You know, we talk about my god, my whole chat's messed up. One sec. All right. We're working on ways to get the YouTube chat back, all right? What up, Zip Zip? What up, Lisandro Peña? What up, Kafka Esquire? Chicken Marsala? Aquila? How we doing, folks? Almost ready to go. Welcome, everybody. Welcome. Happy Monday. Murder Machine Propaganda, says Lisandro Peña. Good to see Lisandro Peña again. Good to see Kafka Esquire. Hope everyone's having a wonderful Monday morning. It's one of those days, isn't it? We're 3 days away from 9/11. And whenever this time comes during the year, I get recommended a bunch of 9/11 videos. I don't know about you guys, but it's a very somber, pensive time for me. But I hope you guys are doing well. Agenda for today, not going to be a super long stream. Today we have Live and Learn at 7 Eastern time, and then I'll do probably some questions afterwards or some, I don't know, call-ins, stuff like that. But yeah, we're going to do a little bit of a recap of the Tim Pool discussion, and then talk a little bit about the Prime Kai discussion, which I also put on my YouTube channel. You guys, it's really funny when you like and sub to the channel. Like the video, sub to the channel. It's also very funny when you leave a comment. And I know I can count on Only Pencil or Alessandro Peña or all the haters. They're leaving comments, so they're kind of one-upping the fans. What up, wifey? Hello, finally a morning stream. Yeah, the trip to West Virginia left me scarred and deformed. But I wanted to give a little bit of a recap to what happened there. Just give me a second to adjust my little hoodie. Okay, bit of a recap. First, let me say thank you guys for watching. Thank you for subbing. Thanks for all this stuff. First off, traveling to West Virginia is always a bit of a trip. I like to take the train in. It's probably about a 3-hour train ride to Union Station in Washington, D.C., and then another hour and a half by car to get to the West Virginia compound where Tim Pool either lives. I think he lives there. When I got there and arrived, there were some protesters protesting the National Guard presence. I didn't see any National Guard members outside Union Station. I went up and talked to some of the individuals who were protesting, and they seemed pretty chill. Some of them were from out of town, though, for sure. Paid protesters by George Soros. Oh, is that why you were MIA? Yeah, actually, if you go to my channel, I recently had another discussion with Tim Pool and others, which we're going to get into. But they were holding up signs, listening to Bob Marley. And this was late at night too, because I got in pretty late. That would have been Friday or Thursday night into Friday morning. Okay. And yeah, no, I think it was sobering also to talk to the Uber driver who took me initially to the Tim Pool compound. He was like, it's all a bunch of bullshit. The whole National Guard presence, and he said it was all garbage. He kind of lightened up because he asked me what I was doing here, and I was like, well, I'm actually here to discuss the DC National Guard presence as well as National Guard presence across the country for domestic law enforcement. And he was opening up, and I asked him what he thought of it, and he's like, this is all garbage, all bullshit. We don't want him here. Now, that is an anecdote, I'm told, and it is an anecdote, but take it for what you will. But we'll definitely get into the actual discussion a little bit in a second, so you can get into my head. Did you hear about the summary judgment granted in the TPS case? I take very little stock in like district courts rulings on TPS because this Supreme Court has been so deferential to the administration on TPS, and so don't count your chickens before they hatch when it comes to TPS. Okay. All right. So let's get you into the mindset of the Tim Pool situation. So I always prefer the studio appearances than the live appearances, because the studio appearances is where you can really drill down and where I think my debating style is most apt to have its effect. And so I would say much more confident in the studio discussions than I am like the crowd situation, especially when the crowd is very, very hostile. Not to say that I won't do it, and I still might do a live appearance sometime in the near future for them. That's another thing to say and mention every time, is you can't trust these people. They're, I think, forces for evil, but behind the scenes, they are very affable, very nice. I found this is true, surprisingly, of Alex Stein, and I found this is true for Tim Pool and all his staff and producers and stuff. Behind the scenes, very chill. You know, they're just like shooting the shit and very accommodating. You know, they pay for your travel, all that stuff. So once again, I found that they're very accommodating, very nice. But yeah, I might do some other appearances with them in the near future. Just heads up on that. In terms of the setup, the discussion was supposed to be centered around the National Guard deployments. And I imagined and suspected that we would get into some like bullshit crime statistic comparison that they always like to do, right? Tim and these people, they always want to bring up like crime stats and do some kind of like messed up story. I mean, there are a lot more that they could have used other than, I almost think that like the bulldozing homes thing that Tim kept going back to, which I'm told, though I haven't looked into it, is a bullshit representation. I'm going to pause for my recap real quick to say, editor, you can pause right there. I just saw a headline that CNBC that SCOTUS now permitting Trump to remove the Dem-appointed FTC member Rebecca Slaughter. Oh, well, that means the end of Humphrey's executor. I mean, that's breaking news if that's happening. If that's true, we'll just turn to that right away. Because that's Humphrey's executor. Oh, it says for now. That's Axios. Let's see. But it still probably is. Yeah, that's going to be the end of... Oh, no, this is an admin stay, right? Okay, don't worry about it. I mean, you should worry about it, because Humphrey's executor is probably dead. And I might actually go over Humphrey's executor with you guys. This is a recommendation by Joanna, and I think it's worth doing. Here, I'll show you guys what Josiah's talking about real quick. So this is an admin stay. It's not a merits stay. And so there was the FTC, which is the Federal Trade Commission. Excuse me, sorry. That was part of the new regulations from the 30s and 40s that was upheld as constitutional in Humphrey's executor. So we'll go over Humphrey's executor at some point. Okay? But this is just an admin stay, meaning it's not a merit stay. And you can tell by one, its time, right? So September 15th. That's like in less than about a week. And you can tell because there's no really dissent, and there would be dissent if this were a merits stay. Okay. So yeah, don't read into the merits here. Howdy, what's up, Falls? Okay. We'll get to legal stuff in a second. I just want to get back to where I was. Don't distract me. All right. So when you're doing these kinds of debate appearances on anything tangential to crime, oh wait, new Supreme Court ruling as well on rates. One sec. We'll take another pause, just real quick. I want to read this one, actually. Everyone chill. This could be very relevant. Supreme Court. I need the order. Kawhi Leonard was a no-show job where he got paid $50 million for doing nothing. Oh, this is bad. This is bad from SCOTUS. So this is a merit stay. And this is bad. And it's another example of the Supreme Court bending over to the authoritarianism. You'd never see this kind of thing if Biden were in office, but I just want to show you what I suspect it is. So we'll take a break from this is breaking news real quick. Okay, so if you remember, this is the case in which the Trump administration was racially profiling and just doing a bunch of warrantless stops without any rational basis. So try to remember that fact pattern, that in California, they had this ICE deployment, this DHS deployment, that was basically just stopping people because of their perceived ethnic origin, because of where they were going to work, without any reasonable suspicion. Reasonable suspicion is the constitutional standard under Terry versus Ohio to detain someone temporarily for a crime. It's a lower standard than probable cause. And in the Ninth Circuit opinion, they lay out a bunch of facts of different people who were stopped, including individuals who are U.S. citizens, including individuals who are legally here, just because they were like at a car wash and looked Hispanic, or they were outside a Home Depot or something, and because they had an accent, right? So this is part of the administration's continuing assaults on individual rights and deprivations, and so we're going to now examine the court staying, this is a merits stay, the lower opinion. The application for a stay presented to Justice Kagan and by her referred to the court is granted. So they're granting what Trump is asking for. It's another example, right? I don't know if you guys recently saw the Ezra Klein video on the Supreme Court basically letting Trump stop payments that Congress has approved of, fire anyone he wants, and dismantle agencies, even though Congress established them, do a bunch of corruption, and violate different disclosure laws without the court stepping in. So there are a bunch of different areas where the court has stepped in to basically usher in this new authoritarianism. And on the one area in which they were seeming to put some resistance, that is, in the kind of totally due process-less renditions of individuals to a torture chamber in El Salvador, there the court upheld that it was illegal, but didn't really do much when the Trump administration kept violating their order. And on other renditions to like third countries, third country removals. They have basically allowed the Trump administration to proceed with renditions that are denying due process because of various different procedural issues, various different bullshit, essentially. Allowed FTC removals, that's an administrative stay currently, falls. So even though I do think they're likely to overturn directly Humphrey's executor, it is currently just an administrative stay. This is a merit stay. So big picture, the Trump administration is doing a bunch of things that most presidents and most people understand to be illegal and understood to be illegal for the longest time. I'm going to repeat them again, right? Stopping Congress from appropriating aid, right? So Congress passes a law to send money to a given place. It's one of their core powers. And Trump just says, nope, not going to do that. And the Supreme Court has essentially, for various bullshit procedural reasons, said that can continue. Dismantle agencies and get rid of, essentially, the civil service laws. And for various different garbage unitary executive reasons, stamp that. Get rid of jobs, which are independent agencies, where Congress enacted some protection from removal for independence, whether that's the NLRB, whether that's independent inspectors general, whether that's the Office of the Special Counsel. Supreme Court said, nope, all that's unconstitutional, Trump wins. When it comes to various different illegal removals, yes, they protected on the Kilmar situation where there was literally an admission that what they were doing was illegal. They didn't move much to try to enforce that order. And for different removal situations, including without due process to third countries, they basically said, oh, our hands are tied, our hands are tied. Any one of these like separation of powers issues, this is all disgraceful from the Supreme Court. They're ushering in, I want to repeat, an era of corruption authoritarianism, totally beyond the pale. And the setup here is the DHS sent out a bunch of their brown shirts in California to just stop people because they look Mexican or Hispanic or they have an accent and they're like near a job site. Without any reasonable suspicion, the Supreme Court must be aware that Trump didn't even argue in court that many of these different stops were constitutional. So they're not even willing to go into court and say, yes, this was a based stop because we did have reasonable suspicion. They're not even in court arguing that fact. So that's the setup here. This is from California. The July 11th, 2025 order entered by the United States District Court is stayed pending the disposition of the appeal in the Ninth Circuit. And disposition of a petition for writ of certiorari if such a writ is timely sought. Should certiorari be denied, the stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of the court. Kavanaugh concurs. So this appears to be a kind of 6-3 decision here. Let's see what Kavanaugh has to say. I vote to grant the government's application, this is Trump, for an interim stay pending appeal of the district court's injunction. The INA authorizes immigration officers to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States. Immigration officers may briefly detain an individual for questioning if they have a reasonable suspicion, based on specific articulable facts, that the person being questioned is an alien illegally in the United States. The reasonable suspicion inquiry turns on the totality of the particular circumstances. The government estimates that at least 15 million people are in the United States illegally. Many millions illegally entered or illegally overstayed just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. About 10% of the people in the LA region are illegally in the United States, meaning about 2 million illegal immigrants out of a total population of 20 million. Not surprisingly, given those extraordinary numbers, more political posturing, in my opinion. Just look at the terminology being used here by Kavanaugh. U.S. immigration officers have prioritized immigration enforcement in the LA area. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, or who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants and do not speak much, if any, English. So what Kavanaugh is saying is any immigration, he's not specifically stating it, but essentially he is, even though he says it's a totality of circumstances analysis, right? A totality of circumstances analysis. He's basically suggesting that a person who is gathering in a location, gathering in a car wash. So if you're hanging out in a car wash, and if you don't speak much English, that's enough for reasonable suspicion. If you're also, I guess, in LA, unclear. So as long as you're in a location where people are hired for day jobs and you don't appear to speak much English, the government is allowed to stop you under reasonable suspicion. That is insane to me. If the officer learned that the individual they stopped is a U.S. citizen or otherwise lawful in the U.S., they promptly let the individual go. Not true. There are many different cases of them holding on to them for sometimes days. If the individual is illegal in the United States, the officer may arrest the individual and initiate removal. Immigration stops based on reasonable suspicion of the illegal presence have been an important component of U.S. immigration enforcement for decades across several presidential administrations. In this case, however, the district court enjoined U.S. immigration officers from making investigative stops in the LA area when the stops are based on the following factors or combination of factors. And we went over these different factors, 1 through 4. And remember, they're allowed to consider these factors if there's one other factor, right? Like, you can't have 1 to get reasonable suspicion. You can't have 2 to have reasonable suspicion. You can't have 3 to have reasonable suspicion. You can't have 4 to have reasonable suspicion. And you can't have these combined to have reasonable suspicion. But you can, if there's a 5, right? Now you can consider all this stuff. But you can't just go off of these 4. And those 4 are presence at a particular location, type of work one does, speaking Spanish or accented English, or apparent race or ethnicity. And this is defining what the LA area is. The government contends that the injunction will substantially hamper its efforts to enforce the immigration laws in the LA area. The government therefore asked the court to stay the district court's injunction. It's hilarious because what the government is saying is we need to be able to just stop people on the basis of race. We need to just be able to stop someone on the basis of the type of work they do. We need to be able to stop them because they speak English with an accent. We need to be able to stop them because they're just present at a particular location. So the government is saying we absolutely need to be able to stop people on the basis of these different considerations in isolation or collectively. To obtain a stay from this court, the moving party must demonstrate a fair prospect that if the district court's decision were affirmed on appeal, the court would grant cert and reverse. The moving party also must show irreparable harm. These factors, by the way, these factors are basically not considered by the court. This is just a fugaze. The irreparable harm factor, public interest factor, these are like, the court doesn't give a shit about these. In my view, the government has made a sufficient showing to obtain a stay. To begin with, given the significance of the issue to the government's immigration enforcement efforts, this court would likely grant cert if the Court of Appeals affirmed the district court's injunction. Excuse me 1 second. Oh, is the trade deficit up 31%? Does this end our right to remain silent? What if they just don't speak? This is not requiring you to cooperate. And I would recommend to people to probably not help the administration in general. In addition, on 2 alternative grounds, the government has demonstrated a fair prospect of reversal. First, under this court's decision in LA v. Lyons, plaintiffs lack Article 3 standing to seek a broad injunction restricting immigration officers from making these investigative stops. So, in addition to the kind of like merits reversal, alternative grounds on standing, in Lyons, the court held that standing to obtain future injunctive relief does not exist merely because plaintiffs experience past harm with fear of recurrence. What matters is the reality of the threat of repeated injury, not subjective apprehensions. But once again, we went over this in the district court. And what we went over in the district court was, this is the kind of thing where it wouldn't be possible to atomize to a specific individual, because it's very unlikely that individuals are going to be able to rely on the police having lists, right? On the one hand, this on the kind of universal injunction ground. That, I guess, is more on the universal injunction ground. But secondly, like, these administration officials are promising to continue doing the same exact shit. And many of the individuals have been stopped more than once. And so I don't know that we're in a one-off situation. This is like a pattern and practice situation. Plaintiff standing theory largely tracks the theory rejected in Lyons. Like in Lyons, plaintiffs here allege that they were the subjects of unlawful law enforcement actions without reasonable suspicion. And like in Lyons, plaintiffs seek a forward-looking injunction to enjoin law enforcement from stopping them without reasonable suspicion. But like in Lyons, plaintiffs have no good basis to believe that law enforcement will unlawfully stop them in the future based on the prohibited factors, and certainly no good basis for believing that any stop of the plaintiffs is imminent. So you could have apparently by Kavanaugh's logic, is you can have like a racial stop policy all in the red states. And what is the reason to think that? I mean, this is, in essence, part of it is a racial stop policy. I mean, substitute little 4 here, apparent race or ethnicity, substitute that with black people, right? So can you stop people on the basis of their propensity to do crime because they're black? I mean, this is, in essence, kind of like a racial policy. And we're explicitly allowing them to take into consideration race even in isolation, right? Even if the stop is solely based on race. What the court is saying here under their standing theory is like they couldn't bring this to court, which is wild. Therefore, they lack Article 3 standing. Absent a sufficient likelihood that the plaintiffs will again be wronged in a similar way, they are no more entitled to an injunction than any other citizen. Plaintiff standing theory. To be clear, plaintiffs have Article 3 standing to seek damages for any unlawful action taken against them. For standing purposes, they distinguish damages and forward-looking injunctive relief. It's very convenient, but again, you have also carved out huge areas of immunity, both qualified and absolute. So thanks a lot for the Article 3 standing on damages, but you have this thing called immunity, different immunity doctrines. These are civil immunity doctrines, and getting rid of like Bivens actions and different cause of action. So it's cold comfort because there isn't really no real alternative for these people to seek money damages from the government for unquestionably unconstitutional stops. So thanks a lot for that, Kavanaugh. Plaintiff standing theory is especially deficient in their case because immigration officers also use their experience to make stops on a variety of factors, like the fact that they look Hispanic, like the fact that they speak Spanish. So even if the government had a policy making stops based on the factors prohibited by the district court, immigration officers might not rely only on those factors if and when they stop plaintiffs in the future. Second, even if the plaintiffs have standing, the government has a fair prospect of succeeding on the Fourth Amendment issue. Oh, do tell. To stop an individual for brief questioning about immigration status, the government must have reasonable suspicion. Reasonable suspicion is a lesser requirement than probable cause and considerably short of the preponderance of the evidence standard. Whether an officer has reasonable suspicion depends on the totality of the circumstances. Here, those circumstances include that there is an extremely high number and percentage of illegal immigrants in the LA area. So replace this with black people, right? There is an extremely high number of black criminals in the LA area. That those individuals tend to gather in certain locations to seek daily work. All right, replace that with they tend to be in locations where there's crime happens, okay? That those individuals often work in certain kinds of jobs, such as blah. So, these black people, tend to work in the drug trade, and that many of these illegal come from Mexico or Central America and not speak much English. Many of these individuals who are black speak in a distinctive kind of way. So, I mean, tell me, would that be enough for reasonable suspicion in the regular context of an American? You're in a high crime area, you see someone who matches some stereotype of a criminal, but doesn't have any articulable facts as to them having committed a crime. It's just based on the stereotype, and you stop them. That's all it takes for reasonable suspicion now? That's nonsense. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Under this court's case law regarding immigration stops, however, it can be a relevant factor when considered along with other salient factors. Like, they're always gonna, okay, if you take as, quote, another factor, the fact that it's in LA, okay, you can take race into consideration. I mean, this is what Kavanaugh's saying, all right? You can take race into consideration, plus some other factor, like the fact that you're in LA, right? You can take in race plus the fact that they look like they're doing construction. It's pretty wild. I mean, like, you're essentially saying you can use race not for like its confirmatory power to like fit a prior description, right? It's not saying that you can use race to confirm that there's a suspect who happens to meet that description. It's saying you can use race or ethnicity for its propensity value. That is, because we know that Hispanic people are more likely to engage in this kind of illegal activity, we can use that propensity to make as part of our analysis to make that stop. It would be like saying, right, that for reasonable suspicion, and notice the weasel words here, that for immigration stops, well, why does it exclude, like, why is it that reasonable suspicion, you can use race for immigration reasonable suspicion, but not for criminal reasonable suspicion? Like, why is race okay for reasonable suspicion for immigration stops, but not for other kinds of stops that aren't immigration based? It's a pretty wild leap to assume that the constitutional right, the Fourth Amendment, this is an originalist, by the way, that the Fourth Amendment is incorporating some different standard of reasonable suspicion, which, by the way, is another term that doesn't appear in the constitutional text, but put that aside, that as part of the Fourth Amendment analysis, the standard of reasonable suspicion changes based on whether it's an immigration stop or some other stop. When we have the Fourth Amendment being passed in the 1700s, before there was any restrictive immigration law or any like crime-based immigration policy or any kind of restrictive immigration policy. So this is the originalism, by the way. An originalist says, yes, for and the reason is because they want to apply an immigration exceptionalist framework to their case law. But it's like cold comfort, right? Because once you put a hole in reasonable suspicion in the Fourth Amendment, Trump is just going to put everyone in that hole. Once you say that like race is a okay factor to consider, oh, but just for immigration stops, or you try to limit your statement to that, it's like kind of making a hole in due process. You've made a hole, and now people are going to try to put everything through that hole, as the administration is trying to do. Under this court's precedents, not to mention common sense, those circumstances taken together can constitute at least reasonable suspicion of illegal presence in the United States. So explicitly race-based, not on confirmatory observations, but on propensity, right? On propensity of a race to engage in illegal activity. We are going to let cops take into consideration the fact that you're Mexican or that you're Hispanic or that you look Hispanic as part of the analysis to whether or not to stop you explicitly. That's what Kavanaugh is saying. Now, it's a concurrence, but it is explicitly what he's saying. Importantly, reasonable suspicion means only that immigration officers may briefly stop the individual and inquire about immigration status. If the person is, and that's what the Trump administration is doing, right? And if the Trump administration were doing something else, you'd have a problem with that, wouldn't you, Kavanaugh? If the person is a U.S. citizen or otherwise lawfully in the U.S., that individual will be free to go after the brief encounter. Only if, and this is basically saying, oh, it's no big deal. It's a brief encounter. What's a brief encounter? So if you're a U.S. citizen and you're being stopped more because you look Hispanic and the immigration officer is detaining you on the basis of the fact that you look Hispanic, what's the harm? It was only a brief encounter. Only if the person is illegal in the United States may the stop lead to further immigration proceedings. That's the whole thing, isn't it? That's what we're worried about, right? Only if they're here illegally can you continue the that's the whole point of what we're talking about is this administration not only can't be trusted to make that determination whether someone is here illegally, they're trying to denaturalize people and they're trying to deport people who are here with status and without due process. So in the context of an administration, right? So in the context of an administration that is not giving due process and is making all sorts of different mistakes, you're saying, oh, don't worry. This won't be a big deal. It'll be brief encounters. And if you're not illegal, you have nothing to worry about. Well, I'm sorry. We have people who are being put on planes illegally without any judicial oversight whatsoever. And you guys are given, in some cases, like your check mark of approval there. So you're really fucking around, and we're all going to have to find out, Kavanaugh. In short, given this court's precedents, like that matters to you. Come on. I mean, the court's precedent, we're about to have Humphrey's executor overturned, and you're over here talking about precedent, to say nothing of Roe and Chevron. Like, it's like the Reaper, the Grim Reaper, walking through every door. It's like Roe v. Wade, Chevron, Humphrey's executor. Oh, but not these precedents, not the racist precedents. And by the way, I mean a little tongue in cheek. I actually don't think that Kavanaugh is fairly representing the precedents here. To conclude otherwise, the court would likely have to overrule or significantly narrow two separate lines of precedents, the standing precedents and the reasonable suspicion precedents that he's interpreting to say that you can stop people based on race, but only in immigration, right? Is there any originalist argument for why the reasonable suspicion standard should differ for immigration versus crime? Any originalist constitutional argument? Not one based in policy. I don't think you can find one. Yes, when the framers were designing the Fourth Amendment, they had in their mind that there would be this thing called reasonable suspicion, which was a judicial creation, right? There's this thing called reasonable suspicion, and there's also going to be immigration laws. Oh, wait, those are 100 years away, but okay, immigration laws. And we'll treat them differently, right? We won't even say it, right? We won't put in the Fourth Amendment lesser standard for immigration versus criminal stops, but it'll just be implied. It's so preposterous. It's so fucking preposterous that these people get to call themselves originalists. They should be laughed at. This is an associate justice of the Supreme Court. And they're basically here just to sign off on Trump's executive takeover. We are living in an authoritarian state, by the way. I hope you know that. Ezra certainly is right about that. That it's not like this is authoritarianism. The government is using the trappings of its own power to go after political rivals. The government is now seizing the different branches' authorities, including appropriations powers, including immigration laws, right, which are supposedly in the domain of Congress to pass, including all the various different things that we've talked about. The government has also demonstrated that it would likely suffer irreparable harm, as the court has indicated. Any time the government's enjoined, it suffers a form of irreparable injury. So this is pretty circular, right? It's pretty circular. Anytime we're prevented from enforcing statutes, the government's injured. Okay, cool. So it is in this case, particularly given the millions of individuals illegally in the United States, the myriad significant economic and social problems caused by illegal immigration. Nice. So now Kavanaugh is making a bunch of policy arguments on illegal immigrants bad, and the government's efforts to prioritize stricter enforcement of the immigration laws enacted by Congress. Notably, moreover, the district court's injunction threatens contempt sanctions against immigration officers who make brief investigative stops later found to violate the injunction. The prospect of such after-the-fact judicial second-guessing and contempt proceedings will inevitably chill lawful immigration enforcement efforts. So now there seems to be a different suggestion here. The theory, right, of the vigorous executive, of chilling the executive, has now extended to the mere notion of a court injunction prohibiting illegal conduct by ICE officers. So now you see Trump versus the United States, this whole like vigorous executive general gestalt is saying, well, we can't have an injunction that prevents illegal action because it would unduly chill lawful immigration enforcement efforts. This shit is gross, man. On the two most critical factors, therefore, the government has demonstrated a stay is warranted. Turning to the balance of harms and equities, as with many other applications for interim relief to the court, the harms and equities may appear weighty on both sides. In those circumstances, to borrow Justice Scalia's apt words from a different context, trying to determine whether one party's harms or equities outweigh another party can be akin to judging whether a particular line is longer than a particular rock is heavy. Moreover, in a case like this involving government action, balancing the harms and equities is difficult. That is because a court must balance the harms to the regulated and negatively affected parties, not only against the harms to the government as an institution, but also against the harms to third parties. There can be a situation where, based on the record before this court, it appears that a temporary injunction or stay would not impose much, if any, harm. But especially in cases involving a significant new law or government action, the interim harms and equities are typically weighty on both sides. In those situations, as I have explained before, resolving the application, therefore, will often depend on the court's assessment of likelihood of success on the merits. So he's basically saying we should pretty much only, on any important issue, decide who's right. So this whole new shadow docket thing, is like, we should just do this for everything. We really shouldn't be weighing these other factors for the stay, and we should just be like, who deserves to win? Talk about judicial supremacy. In any event, the balance of harms and equities in this case tips in favor of the government. The interest of individuals who are illegally in the country and avoiding being stopped by law enforcement for questioning is ultimately an interest in evading the law. That is not especially legal. Obviously, dipshit, the interest here is to be free from unreasonable searches and seizures. And that applies both to people here without any authorization and people who are here without any authorization, both with and without. Yes, people who are here illegally, people who are criminally, can be subject to unreasonable searches and seizures. That's the whole point of the exclusionary rule. The exclusionary rule is supposed to protect criminals, right? You're not allowed to use the fruit of the poisonous tree, and so you're protecting criminals when you prevent them from, the government that is, from using evidence from an illegal search or wiretap or something in a trial. So what a disrespect for the Fourth Amendment, which is specifically to protect the interests not just of criminals, but of all Americans and all people in the country. To be sure, I recognize and fully appreciate that many, not all, but many illegal immigrants come to the United States to escape poverty and the lack of freedom and opportunities and to make better lives for themselves. And I understand that they may feel somewhat misled by different varying approaches to U.S. enforcement. But the fact remains that under the laws passed by Congress and the president, they are acting illegally by remaining in the United States, at least until Congress and the president choose some other legislative approach. And by illegally immigrating and remaining in the country, they are not only violating the immigration laws, but jumping in front of the non-citizens who follow the rules. And now we have a big exposition about why I'm a good guy. I just like beer. Kavanaugh is a joke. This is all political. I recognize, of course, my hands are tied here. Of course they're allowed to consider your race when stopping you, because that's just what the president's allowed to do now. And I know that you feel a little confused and misled because it's been so crazy, right, guys? But I'm a good person. I might have a different policy, but I can't really do anything. This guy's such a scumbag, man. For those reasons, the interest of illegal immigrants in evading questioning and thus evading detection of their illegal presence are not particularly substantial as a legal matter. Are they anything, right? So like here you're saying they're not particularly substantial. What does that even mean? You're not weighing them a lot, but like, would you ever make this argument of individuals who are blatantly having their homes searched without warrants in violation of the law? Oh, yes, but they're criminals, and so they don't have any kind of interest in evading detection. Well, no, but the framing of it is doing all the work. If you frame it as an interest in evading detection, yeah, obviously you don't have an interest in that. But if you frame it as, I don't know, rights deprivations, maybe it's something different. And I think it's better thought of as a rights deprivation than evasion. I mean, this would put a road through all of the Fourth Amendment. Moreover, as for the stops of those individuals who are legally in the country, the question in those circumstances is typically brief. And the individuals typically is doing a lot of work here, may promptly go free after making clear to the immigration officers they're U.S. citizens or otherwise legally in the U.S. I just have to say, real quick, who believes this? Yes, once you make clear to the immigration officer, they're going to be very nice to you and just let you free very gently. This is the whole problem. We can't trust these immigration officers, bro, because these are brown shirts who are pretty much sociopaths, at least the ones doing these kinds of raids. And no one trusts them, and they're doing a bunch of illegal shit, which is on the record, which you're ignoring. You're ignoring all of the clearly illegal stops that are before you, Cav, in the record. Oh, just make clear to these guys, these people who are deporting individuals without any due process, who are revoking visas, legal visas, because of thought and expression. And you're like, oh yeah, just make clear. Just talk to the police, right? After making clear. I mean, even this, he's presuming, right, after making clear that you would talk to these immigration officials. Which is a wild assumption. Cav is a joke, man. Just make clear to the police that you're innocent. Would you ever hear them say, by the way, this of like a criminal? Because remember, it's the same legal principle here. It's the Fourth Amendment. That's why I keep going back to the criminal context. Because it's the same constitutional principle at issue here, either through the Constitution itself, which there is a principle through the Constitution itself, but also because of the law assumes the constitutional standard, the statute. Would you ever hear Kavanaugh be like, well, if you just make clear to the police officer that you're innocent of the crime, then they'll let you go. in a Supreme Court concurrence, right? How many of you have seen like the what's this guy's name? Oh, it's like the crime guy, right? His name is J something. It's J something. You know what I'm talking about? J something, and they like go through all the interrogations. You guys will know it. JCS, right? Yeah. Imagine like, okay, this is the Supreme Court, and JCS like, you probably shouldn't talk to the law, even if you're innocent. The Supreme Court, like, dude, no one should be basing their balance of equities on the stupid assumption that individuals should make clear to the police that what they're doing is legal, and that is like envisioning some sort of long conversation with law enforcement. It's wild. Finally, although the dissent emphasizes the force allegedly used by immigration officers, that is not the issue in this case. Of course not. The district court enjoined the government from stopping individuals for questioning based on several enumerated factors. The injunction is silent as to the use of force, and it is not necessary for the injunction to address that use of force, because the Fourth Amendment's reasonableness standards continues to govern the officer's use of force and to prohibit excessive force. To the extent that excessive force has been used, the Fourth Amendment prohibits such action, and remedies should be available in federal court. Remedies should be available. They should be available. Now, what do you mean by this, Kavanaugh, that they should be available? Like, we should pass a law getting rid of qualified immunity? That we should maybe read in more causes of action into the Constitution? But you've been loath to do that. It's been your job, as well as the conservative majority, to limit as much as possible the amount of remedies that individual citizens can have to get to underlying rights deprivations. I mean, where are we at here, folks, right? There's basically little to no civil immunity. I'm sorry, civil liability, because we have the doctrines from Fitzgerald and qualified immunity for the president, Fitzgerald, and qualified immunity for officers. There's no like criminal liability for the president, so he can't get in trouble. The amount of damages actions that can be done has been severely curtailed because of qualified immunity and closing down of Bivens. So like, what is left? How do we actually enforce people's rights anymore? And now you're even saying like, we can't even get injunctions. So the whole facade here is crumbling. It's crumbling, man. Like, how do we prevent illegal action anymore? You're basically saying you can't go to the courts because an injunction is going to unduly chill law enforcement. You can't get a class action or sorry, anything resembling what should be a class action because it's a universal injunction that isn't authorized by the Judiciary Act of 1789. You can't have an implied cause of action. You don't have sufficient standing because of some bullshit interpretation of our precedent, which isn't even true. Like, the amount of barriers that the court is putting to vindicating domestic liberty is insane at this point. They have constructed a facade to basically make the president close to a king. And even when he's like clearly intruding on other branches' powers, they're like, oh yeah, it's non-justiciable, it's a political question, you know, he wins because of the president. If you care about this, he must be impeached. It's so depraved. And by the way, I also blame Anthony Kennedy for retiring during the Trump administration. That guy deserves a bunch of your blame. I agree with the dissent on this point, but to reiterate, this injunction against brief stops for questioning does not address the use of force issue. In short, the balance of equities favors the government, especially in an immigration case like this one. It is also important to stress the proper role of the judiciary. Why? The judiciary does not set immigration policy or enforcement priorities. Why especially, right? Like, especially. The judiciary supposedly also doesn't set criminal policy. Once again, right? There's this immigration exceptionalism that is nowhere found in Article 3's mandate that the judiciary resolve cases or controversies. There's a plenary power doctrine for immigration that, yes, that is true. The federal government has plenary power. But that doesn't imply a reduced role for the judiciary. But once again, it seems to be that Kavanaugh and the conservative majority here is suggesting that if it deals with immigration at all, we're going to apply lesser constitutional standards. We're going to be more willing to hem in our authorities as judges to say what the law is. It should come as no surprise that some administrations may be more laissez-faire in enforcing the immigration law and other administrations more strict. Dude. So he's implying Biden here. He's taking a shot at Biden. Thank you, Cav. Article 3 judges may have views on which policy approaches is fair or better, but judges are not appointed to make these policy calls. Yeah, I mean, not to make the policy call, but to make the constitutional call. And if your constitutional call rests on a starting set of assumptions on the policy, then it seems like you are making a policy call by allowing your policy priors, which I think they are, to infect your constitutional analysis, which I think it is. We merely ensure in justiciable cases that the executive branch acts within the confines of the Constitution and federal statutes. No, you don't. You don't do this. When have you done this? When have you actually done this, Cav? In the last 3 months. What you are doing here is just rubber stamping whatever the president does. That's what your job is right now. Just as this court a few years ago declined to step outside our constitutionally assigned role to improperly compel greater executive branch enforcement. This is him saying, I'm not biased. I'm not biased. This is like him doing my thing. I criticized Biden. He's doing the equivalent of me being like, I called it, the pardon's impeachable. And by the way, I would love to see I mean, okay. He was in the majority. Roberts joined by Breyer, Sotomayor, and Kagan and Kavanaugh. A bare majority. Excuse me, guys. 1 second. 1 sec. Whenever I come back to this apartment, I'm like, I struggle. Is there something wrong with my air quality? Where is the abundance movement to help my air? I feel like I'm when I went to Tim Pool's compound, I have no problem speaking. I have no problem articulating. But when I'm in my apartment, I feel like I can't. Sometimes I lose my breath. It's crazy. Maybe I should turn on my air purifier in my streaming setup. All right, sorry. Executive branch enforcement of the immigration laws must be maintained, and we can't step outside of our assigned role. Black mold, you think? Should I check for black mold? In sum, the government has demonstrated a fair prospect of success in the merits. Okay, cool. Let's see the dissent. You're in New York where the air is liberal and weak. In early June, the government launched immigration enforcement raids across LA. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks, and seized individuals on site, often before asking a single question. A federal district court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment. Based on the evidence before it, the court held that the government was stopping individuals based on 4 factors. These are the 4 factors. Concluding that stops based on these factors alone, even when taken together, could not satisfy reasonable suspicion. The district court enjoined the government from continuing its pattern of unlawful mass arrests. Instead of allowing the district court to consider these troubling allegations in the normal course, a majority of this court decides to take the once extraordinary step of staying the district court's order. So this is Sotomayor saying that this entire thing has become not extraordinary. That decision is yet another grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent. And it's not the first time that these freedoms are being lost. In early June, the government launched Operation at Large, deploying roving patrols of armed and masked immigration agents. Over the course of the next month, the government made nearly 2,800 immigration-related arrests. All right, so we know the facts here. And these are the bunch of individuals who were stopped, which we've read before. And this is the procedural history, which, again, we've read. And these are the stay factors. There's an especially heavy burden when there's a pending Court of Appeals review. Ordinarily, the court considers the applicant's likelihood of success in the merits, irreparable harm, and balance of equities. The government, and now the concurrence, this is Kavanaugh, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. Totally true. How can anyone say this is a mischaracterization? Kavanaugh is basically saying that Latinos, on the basis of the propensity, right, not just on matching a description of a particular person who committed a violation, but because of their propensity to commit immigration violations, that's something that the country and their law enforcement can take into consideration during stops in the interior of the country. As the district court found, and the government does not meaningfully contest, the present evidence reveals that the operation at large seizures happened based solely on the four enumerated factors. The government now asks this court to bless that conduct, at least temporarily, by issuing a stay. The government, however, has not demonstrated the necessary likelihood of success. The Fourth Amendment imposes limits on searches and seizures. Wherever a police officer accosts an individual, he has seized that person, and the Fourth Amendment requires that the search be reasonable. All right, thank you. I'll get a carbon monoxide sensor. As relevant here, officers may stop an individual only if they are aware of specific articulable facts that get reasonable suspicion, quoting Terry versus Ohio. Critically, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people. In Brigioni Ponce, for example, the court held that Mexican ancestry alone did not constitute reasonable suspicion to support stops. So too in Brown versus Texas, the court held that standing in an alley in a neighborhood frequented by drug users was not reasonable suspicion, right? So, and this makes sense from the context of like the criminal, excuse me. One second, folks. I'm going to try to do something. One sec. All right, I'm back. Okay. Imagine in the criminal context, right? If you were allowed, there's a drug alley. We'll call this drug alley. And you're just a guy standing in drug alley, right? And I call this drug alley because there's been a lot of drug sales, just like dozens of drug sales that happen here. Do you think that a cop can detain this person, reasonable suspicion, just because he's in drug alley? Now, what if they were to tell you, okay, well, he's in drug alley, but he's also a black person, and black people in drug alley, all the drug sellers in drug alley have been black. And so we're not just stopping him because he's black, we're stopping him because he's in drug alley and he's black. You think the court would ever sign off on that? Maybe they would now. I mean, but this is insane. The Equal Protection Clause is supposed to protect against this kind of stuff. But now you're allowed to take, maybe just for immigration stops, right? For immigration stops, you're allowed to take into consideration someone's race, again, as a propensity matter. Sotomayor continues. The Fourth Amendment thus prohibits exactly what the government is attempting to do here: seize individuals based solely on a set of facts that describe a very large category of presumably innocent people. As the district court correctly held, the four factors, apparent race or ethnicity, speaking Spanish or English with an accent, location, and type of work, are no more indicative of illegal presence in the country than of legal presence. In other words, how are you able to compare those factors alone as a funnel for legal presence and illegal presence? That if you were to use these factors, these four factors, combined or in isolation, you're going to get millions of people here, for sure, but you're also going to get millions of people here. Millions, right? And Kavanaugh says it, right? Like, the government alleges 15 million and what, like 10%? When the overall Latino population is like, what, 40 to 50% in this area? So we're talking about millions of people who are here legally. And if reasonable suspicion means anything, it must protect the vast majority of people. The factors also in no way reflect the kind of individualized inquiry the Fourth Amendment demands. Allowing the seizure of any Latino speaking Spanish at a car wash in LA tramples the constitutional requirement that officers must have a particularized and objective basis for suspecting the person stopped of criminal activity. I mean, this seems to imply that the government tomorrow could write a memo that says, we are ordering all of our ICE officers to have the discretion to seize any Latino speaking Spanish at a car wash in LA and ask them about their immigration status. It does seem to suggest that this kind of explicit memo would be constitutional. Wild times here. Wild times. So if I go to a car wash and start speaking Spanish, they might stop me and ask me if I'm a citizen. And by the way, the people in the chat, they're going to say, this is based. They're going to say it's good, right? We have the people in the chat, the haters, who are like, this is actually good. We like it when we stop any Latino speaking Spanish at a car wash in LA and ask them about their immigration status. We think that that's based. The government, joined by the concurrence, brushes aside this court's precedents with an appeal to probability, arguing that the high prevalence of undocumented immigrants in the Central District should enable agents to stop a relatively broad range of individuals. Without even a citation, the government asserts that 10% of the population in the Central District is unlawfully present, so it is inevitable and unremarkable that the immigration officers would target any Latino person, or any person speaking accented English, or any person standing in a particular type of location, or any person working a low-wage job in the greater LA area. Never mind that nearly 47% of the population identifies as Latino. Never mind that over 37% of the population speaks Spanish at home, and over 55% speak a language other than English. Of course, aggregate statistics cannot substitute for individualized suspicion that the Fourth Amendment requires, citing Justice Kagan. The concurrence acknowledges that the government cannot stop someone based solely on apparent ethnicity, but seems to suggest that combining an individual's ethnicity with any one of the other factors could add up to reasonable suspicion. Right, and he is very weaselly about this. Just own it, dude. Just own it. Don't just imply it, own it. That ignores the obvious reality that ethnicity and language are often intertwined, so relying on only those two factors is no different than relying on ethnicity alone. Even the government does not go so far as to argue that relying solely on ethnicity and language would constitute reasonable suspicion. From here, adding on to the fact that someone appears to work a low-paying job does little to move the needle either. The concurrence fails to explain how the fact helps the agent differentiate between someone who has legal status and someone who does not, considering both kinds of individuals may work these jobs. In fact, the court rejected a similar argument levied by the government in Burgoni Ponce. There, the government asserted that it could stop drivers of apparent Mexican ancestry in border areas because most undocumented immigrants in those areas are Mexican, and most leave the border in a private vehicle. Unlike today, the court there rightly rejected the government's rationales because they could cover a large volume of legitimate traffic as well. Without any suspicion that a particular vehicle is carrying undocumented immigrants, the government's broad statistical approach to reasonable suspicion would subject those residents to potentially unlimited interference, which is precisely, by the way, what the court is doing here. They're using statistics, right, to have a kind of literally a racial profile. So when I say racial profiling, that's literally what the court is allowing. It's saying there's a profile which includes race as a propensity factor, and we're allowed to consider the racial profile, right? And they try to limit it, or at least a concurrence, to immigration stops, but there's no reason that it should be such limited. And even by itself, on immigration matters, it's a problem. But it is literally racial profiling. And I would love to have someone argue that it's not. Rather, the court found that reasonable suspicion requires additional factors, particularly one specific to a given vehicle or individual. The holding and reasoning in Burgoni Ponce clearly supports rather than undermines the district court's injunction. Next, the government moves beyond background demographics and argues that the four factors, limited by the TRO, in some hypothetical scenario, give rise to reasonable suspicion. For example, the government posits that if agents had intelligence that a workplace was, quote, known to have hired 100 undocumented individuals, that the prior week, immigration enforcement officials might well have reasonable suspicion to stop a person at that site. This argument fares no better than the first. As an initial matter, the proffered scenario falls outside the scope of the TRO. A seizure on those hypothetical facts would not rest solely on the four factors, but would incorporate an additional probative fact, the intelligence about a particular employer's recent hiring decision. So nothing in the TRO. So just as a matter of fact, the government's example, hypothetical here. And I love this, by the way, because how many different people do I talk to where they're like, you can't use hypotheticals. These courts use them all the time to understand and ascertain the scope of their rulings and the legal rule. That the government's contention here would fall outside the TRO issued by the district court. The district court issued a TRO, and it only includes the four factors, 1 through 4, in isolation or in combination. But if there's a fifth factor, and here in the fifth factor is this example employer who has this hiring practice, that would be a fifth factor. In any event, operations at large bear little resemblance to the government hypothetical. The government has provided no evidence showing that its seizures were based on credible intelligence about a particular employer at a particular location. Indeed, the government submitted to no evidence about what facts its agents relied upon, right? They didn't even fight in court that what they were doing was legal. Rather, its declarations suggest the government generally targeted locations based on the types of businesses that in the agent's generalized experience, undocumented immigrants supposedly frequent. That is plainly insufficient to give rise to particularized and objective basis for suspecting a particular person. The government and concurrence also attacked the named plaintiff's standing, Lyons does not bear the weight the government and the concurrence place on it and provides no valid basis to justify the majority intervention. Our standing requirements ensure that each plaintiff has a personal stake in the outcome. In Lyons, the plaintiff has sought an injunction against the city of LA after a police officer applied a chokehold to him. The plaintiff lacked standing, the court said, because he failed to establish a likelihood of recurrent injury. The court cited a lack of evidence, for instance, that the city ordered or authorized police officers to act in such a manner. This is so different, right? Because here we actually have a policy. They ignore the record and the evidence. And this is an example, by the way, of the higher court. We talked about this on another date, ignoring the factual determinations of the lower court, of the district court, which they're supposed to give with deference. They ignored the record evidence in the district court's factual findings. To start, the record reflects the government's systematic operation is based on race, ethnicity, blah, blah, blah. And that was a finding in the court. Each individual plaintiff fits that profile. The plaintiffs are almost certain to return to the location in which they were seized because they either worked there or they were on their way to work. The record, including the government's own declarations, further makes clear that a given location is likely to be targeted again and again. The government nowhere argues that any of the district court's findings are clearly erroneous. They're not even saying that they're lying, right? The district court has their facts, and the government is not even contesting them, which makes this holding even more despicable. These findings show that the plaintiffs, by doing nothing more than going to work every day, are likely to be seized again. The concurrence instead contends that the agents also use their experience based on permissible factors. So even if the plaintiffs were stopped again, it could be based on the factors other than the four listed in the TRO. Hypothetically, they could. The evidence in this case, however, reveals the government is likely to continue relying on the four factors. On this preliminary record, the individual plaintiffs have demonstrated that they face a realistic threat of being stopped again. If these people don't have a record of that, who would? Who would have standing? And then we have the organizational plaintiff as well. Finally, the government challenges the scope of the ordered relief in Trump versus Casa, but that is not a sufficient basis for the court's intervention at this stage. The district court found that a district-wide injunction was necessary to afford the named plaintiffs complete relief, and that's allowed by Casa. And then we have the other factors. Okay, I mean, this is enough for us for now. I'll continue reading on, but it just goes to show you, man. Another example of the Supreme Court now giving, even though they technically state, right, you're not supposed to have a stop based on race. And even though Kavanaugh is only a concurrence, they are allowing, right, even if not explicitly holding, they are allowing the erosion of equal protection under the law in an effort to just give Trump everything he wants all the time. And so I bring you back, and we're going to do the recap of the debates in a second, but I bring you back to like Prime Kai. If we had listened to the Prime Kais of the world in 2016, well, some people did, right? And it led exactly to where we are now. Cav, Barrett, Gorsuch. If Hillary wins in 2016, we have none of these people. You don't even know who these people are. And we're likely going to have Alito and Thomas, at the bare minimum, retire before 2024. And the people you have to thank for that are, one, the conservatives and the Trump supporters. That should always be number one on your list. But also the Prime Kais of the world. Anyone who would make this kind of justification that, you know, it wasn't a big enough deal in 2016 or 2024 are basically giving a big middle finger to all the rights that we enjoy in this country and helping usher in an era of unprecedented authoritarianism. But yeah, let me do a little recap of, unless there's other breaking news for us to consider. That's Cap. What's Cap about this? Okay. I'm like not feeling well. I think it might be. Should I check for black mold? Because I was feeling great when I was in West Virginia. All right, let me do the recap, and then I might need to get out of here because I don't feel good. Excuse me. Okay. 50 says cancer. I'm just going to restart on the Tim Pool stuff. So, this weekend on Friday, I'm going to start again. On Friday, I had another debate with Tim Pool, and he always likes to organize some help for his side to have additional conservative people to lean on, to maybe be a contrast to. He did it previously in each one of the appearances that I've made, starting with Good Logic, then Will Chamberlain plus Alex Stein, then Matan plus Gavin McInnes plus Alex Stein, and now with this, I don't remember his name, Joel guy, and this British person that they brought on to discuss the deployment of the National Guard. I always enjoy being outnumbered. I think optically it looks good for the liberal whenever they're outnumbered like that. And it gives me a lot to like push off of and to make like a useful contrast. And oftentimes there are disagreements that you can utilize between Tim Pool and the people he is bringing on. My strategy in that discussion was I expected him to bring up some like crime statistic or to bring up some anecdote, which he did. He brought up this story from like Chicago where apparently they tore down a neighborhood, and he presented this like false dichotomy that I have to choose between bulldozing all the black people's homes or a bunch of National Guard people picking up trash. And that couldn't, I think, have been a better thing for him to start with as far as I'm concerned. I think that dichotomy is so preposterous. It's so ridiculous that anyone would accept that in a discussion about whether the National Guard deployment was justified or not, that we would have to choose between an illegal or unjustified bulldozing of people's homes and the National Guard deployment or military deployment. That is, like, to me, self-evidently absurd. Now, I've been told, excuse me one second, folks. I don't know if you can see it. Excuse me. I put in my air purifier right there, so hopefully that makes a difference. I think this is probably all pseudoscience. I don't think you guys can hear it either. One second. Woo! All right, I'm back. Now, I've been told that what he said about that Chicago neighborhood isn't even true, but it doesn't even really matter for present purposes. Like, just the fact that he is trying to contrast the National Guard deployment with some like other thing that happened in his past, I think it's self-evidently ridiculous. And I think that any like fair-minded audience will see the kind of gamesmanship that he's playing by contrasting those two different, like, very disparate policies against each other and trying to make a conversation that's like specifically about the deployment of the National Guard on like your broader solutions for crime. And so I thought that was a good look. Additionally, I think that like bringing on some insane Christian nationalist who basically says, what did he say there? He goes, all trans people are ticking time bombs designed to kill Christian children. That is also, I think, a nice contrast with myself. And then he being unable or unwilling to like condemn that system of government, that theocracy, or at least to kind of make a false equivalence. Like, you want this shit, you want to bulldoze black people's homes, and he wants a Christian theocracy across the whole country where we're like outlawing blasphemy. Who can really decide between those two things? Again, once it, like, you know, mischaracterizing my position on housing and what I want to do to various different populations. So I thought that was all well and good. I think always when I have these conversations with Trumpers, I start with, do you care whether or not the policy at issue, whether it's deporting Kilmar, whether it's getting rid of Mahmoud Khalil's green card, whether it's deploying the National Guard or Marines and military, whether that is legal or not. That's how I always start with, because I think it's a great indicator of where these people's minds are at. In the case of Joel, he literally repeated the thing that Napoleon said or whatever. He who saves the country commits no crime or doesn't break a law. And that, again, I think is wonderful. And when they get back to those hypotheticals, like, well, you would break the law sometimes, yes, but we're talking about in the American context. We're talking about a threshold within the American context. And I think that all makes them look like authoritarian goons. I always will go back to the use of specific terminology in one case versus another. In the case of like the insurrection application of that term and rebellion, where he's like, oh yes, the burning of the Waymos and like throwing some rocks at ICE officers, that's definitely an insurrection and rebellion because it was so organized. It was really organized. And so unlike January 6th, which was very unorganized, that the LA protest riots, though, that was a rebellion, but not Jan 6 because it wasn't organized enough. Don't you know, I saw like a grandma walk in and they charged her as though that fact were related to whether we're going to use specific terminology for one event versus another. I think that's a good look as well. It shows the inconsistency, the hypocrisy. He's quite willing to call something a rebellion the minute Trump does. He's quite willing to call it an insurrection the minute Trump does. And anytime there's a specific opportunity to press him on that, I will take it. Because Trump is essentially running his administration off of emergencies, executive orders, and unlocking authorities based on like certain prerequisites such as insurrection, invasion, rebellion, that stuff. And so anytime the administration can be needled on their hypocrisy, be Jan 6, I'm going to do it. Other issues that came up, the British guy, you know, was I a little rude to him by saying, listen, you're from the UK, you don't know shit about the First Amendment? The reason I brought that up was specifically because he was suggesting that whether you wave a flag of another country, that is the determining factor whether something is an insurrection or rebellion. I'm like, dude, you don't know jack shit. On the First Amendment, number one, and number two, on this issue of the National Guard deployment or the military deployment, we were trying to get away from like your military standing armies deployments in the American context when we had the Declaration of Independence and charged that as one of the major crimes of the British Crown. which justified secession. So I thought that was a nice little opportunity, and he was kind of left with just kind of complaining about my being rude to him for the rest of the conversation, and was essentially a non-factor. I think anytime someone is focusing on the meta of the conversation, that looks good for me. I think they look like they're complaining, like they're whining. Tim Pool was interrupting, I would say, more than usual. And I think that he was more frustrated and guarded than usual. I sensed that. Another, I think, fantastic moment was near the end where he's like needling me on, isn't it a ridiculous question to ask if you have a preference for one race or another in terms of voting? I don't think it's ridiculous. First of all, we started this whole conversation with a British guy where he was like, I do think we should have a lesser standard for detaining black people than detaining white people. You can listen back to the actual conversation and you can see where he says that. Now he tries to back away from it later, but I ask him a direct question, would you have a lower standard for detaining black people than white people? And he said, if it saves lives, of course. That's what he said. You can watch the tape. So it was completely, I think, his own issue that race became a big talking point of the conversation. That's on him. And later he tried to back away from that and it's like, oh no, we're just noticing things. We're just noticing things. But I mean, you're not just noticing things. You did apply a different constitutional standard to black people than white people. You did suggest that. And you were trying to bait me from when I noticed that, like, yeah, there are some red states with with more crime than some of the blue states where they're proposing these deployments, even in the major cities. I mean, Chicago is not even in the top 10 in terms of crime. He goes, well, why are those red cities dangerous, or why do they have so much crime? And he wants to bait out of me, oh, because black people live there, because black people are inherently more, prone to crime. I think that's what he's pushing for. He struck me as someone who's like very anti-Muslim and very against immigration into the UK. And so that it kind of striking me as a kind of Tommy Robinson type outlook. I'm not saying that he agrees with everything Tommy Robinson does, but just in his outlook vis-a-vis immigration. Other parts of the conversation. Oh, I thought it was very revealing that this Joel guy was like a presuppositional type person. These guys are like dime a dozen. We need to have like some kind of dialogue tree to deal with the presuppositional folks, because it's so hilarious. And I was almost baited into having that conversation, but it's the same kind of people like Andrew Wilson who try to claim that like logic doesn't make sense without a God. God is objective, and without God there can be no logic. The rules of logic and reason don't make sense absent a God. Which to me is basically an unintelligible statement to make. And it's like very easy to make quick work of it. So he almost baited me into those presuppositional conversations. But I wanted to stay on message and stay on the point of the deployment, which frankly we spent a lot less time on than I wished. If there was one thing that I think having even a little bit more discipline would have been better. I thought my demeanor was decent. I think my demeanor is always better in the studios than in the live audience context. You guys can tell me what you think. Some people, I saw some comments being like, you were too nice. I don't know the best way, and this will dovetail into my recap on the Prime Kai conversation, the best way to deal with that critique. Because on the one hand, I get the critique, which I think is well-meaning, that you come off sometimes very shrill and too aggressive and too angry sometimes. And I think that's true. But then there are some people who I think in certain contexts wish I was like more harsh. And there were some people who felt that with the Tim Pool conversation, and there were certainly some people who felt that with the Prime Kai conversation. Now, if you ask me my personal opinion, I thought that I was reasonably harsh against both of them. I mean, I am basically calling Tim Pool a dumbass authoritarian fascist guy, and I'm calling Prime Kai complicit in that as well. And so I don't think that we can make the argument anymore that Pisco is going to treat lefties differently than MAGA people in the sense of it, like in the debate context, optically that much, right? Because optically, I feel like I come across as congenial in the Tim Pool conversation a little bit, though I'm pushing, right? Constantly pushing, constantly asking him questions, pressing him. Same thing with Prime. I think it's about me finding my balance, perhaps, and how to approach these conversations. But yeah, let me know in the comments if you think that I was too nice to Tim or to the other people there, or to Prime, which we'll get to in a second. But I'm happy with how that went. I almost wish we had another hour. Yeah. And it's not about like making sure I get invited back. That's not why, like, I would say anything that's on my mind. It's about me trying to get to the right tone, perhaps, to be like the most effective in that moment. But I'm open to the criticism there. I had a couple snide remarks under my breath that people caught. But in general, yeah, let me know what you think in terms of the topic discipline, in terms of the optics discipline. I think, again, I should slow down a bit. Not all the time, but sometimes I'm just like speeding through things. Thank you so much for the tip. Phenomenal work, man. Handling these weasels. Smart game plan that you would execute with discipline, the way you would steer the conversation back over the Dodgers. Bellissimo. Thank you so much. I really do appreciate it. Yeah. But we'll see about that. We'll see what I think about it. I'm going to ponder it a little bit more. Yeah, that's the Tim Pool conversation. Any questions on the Tim Pool stuff before we move on to Prime Kai? Be genuine. And I think that I always try to be a genuine, authentic representation of myself. It's almost hard for me to be not myself. Now, I can turn up like the anger or the whatever, but I'm someone oftentimes when I'm in these kind of debates spaces that I wear my heart on my sleeve. Very different than how you might behave in like a professional setting where, you don't want to be doing in front of like the judge or whatever, right? Okay. Let's talk about the Prime conversation substantively. So Prime is someone that I like. And similar to Tim Pool, behind the scenes, Prime and I, very, very friendly. I'm very friendly, again, with people like Crystal Ball. Very friendly with a bunch of the other different people who, we think differently on issues. But in general, I like Prime. We have a big disagreement on the merits of the election issue. I actually didn't know / forgot that he didn't vote for Kamala. I thought it was going to be a conversation largely about like chorus stuff. But it very quickly got off like on harm reduction, voting for Kamala type conversation. And frankly, it's a little bit of the same song and dance that you guys have seen among a lot of these leftist circles for years. Although this one was a little worse. Because say what you want to say about the Vanguard, they voted for Kamala. Say what you want to say about Hassan, at least people say that he voted for Kamala. Say what you want to say about Crystal, she recognized that it was, in retrospect, should have voted for Kamala. Say what you want to say about Kyle, same thing. So this is like almost even a worse version of that kind of lefty anti-democrat sentiment, which some versions of I can even sympathize sometimes with people who are like, we don't like the Democrats when they're doing X, Y, Z. But this was really just super synthesized, hyper concentrated version of what I would call lefty brain rot. Even though I do like Prime quite a bit. So of course he's going to have a problem with Chorus if in general he has a problem with voting for Democrats, I think. Not suggesting that Chorus is a partisan organization in the sense of being officially affiliated with the Democrats, but everyone kind of understands ideologically the kind of creator is more center left than full on leftist, full on socialist or whatever. And so it got into a conversation about why it was not okay to vote for Kamala. And then it kind of gets down to the trolley problem, doesn't it? Where Prime Kai takes this like kind of like, I think like hard to explain, perplexing deontological view that one must never vote for the lesser of two evils, regardless of the consequence down the line. And that is like a kind of deontologic value that I could never truly understand. I mean, our minds just think very differently. It at some points feels a bit like a virtue signal. But let me run you down some of the I think problems with that conversation and what he's quote unquote trying to do in the conversation. Again, I'm not ascribing any ill motive to Prime at all. I'm just saying that these are the kind of patterns that I see in the conversation. The first is like this whole, well, she didn't deserve my vote. She didn't earn my vote. I want to say it like very clearly. I think people who use the term deserve your vote, or she needs to earn my vote, or she deserved to lose, I believe that to largely be either confusion or weasel language. I hear it from Prime. I heard it from Ryan Mullally. You don't owe anyone your vote. Now, one thing that's been very helpful by talking to people like Avi and Ask Yourself is getting an understanding of what people mean by that term. When you say you don't owe anyone your vote, well, what do you mean by that? If what you mean is legally you don't have an obligation to vote for someone, then that I would say I agree. You don't owe anyone your vote in the sense that you are not legally bound. You haven't made a commitment that is enforceable, either in the law or I suppose socially, to vote for someone. So in terms of you don't owe, if what you mean by you don't owe someone your vote, as in like you don't have some kind of legal or promissory obligation to vote for someone, then yeah, I agree with that. But typically people mean something more. They don't mean that, right? They don't mean I have a legal obligation to vote for Kamala, or I promised someone I would vote for Kamala. You know? That's not what people mean by the term owe. They mean some other obligation. Like you're not owing Kamala Harris a vote in some other sense. Well, what is that other sense? If the other sense is like, do I have an ethical obligation to vote for someone? Then I think you do owe her your vote, because you owe the most viable, in my opinion, like the least harmful, viable candidate your vote. If that's what we mean by owing someone vote. But like, what do you mean other than that? What do you mean by owe vote other than like ethical obligation to vote for someone? And once you start to clarify what is meant by these terminologies, this rhetoric starts to show its emptiness. The same thing with the kind of like, she deserved to lose. Well, what do you mean by she deserved to lose? And Tobias, Dr. Nierup says the best candidate is better wording. I would say the best viable candidate, perhaps. Because I wouldn't say like if you thought Jill Stein was the best candidate that you should vote for her. But so you have an ethical obligation to vote for them in the two-party system, the best viable candidate. but that's one area of like what I would consider, whether intentional or not, slippery or weasel language, you know? This kind of deserves to vote, owed your vote. Whenever you hear that, that should be sending like alarm bells. Because I think it's a way to like, to dodge the fact that everyone recognizes the lesser of two evils and to divorce that obligation that one would feel to vote for that lesser of two evils and to impose instead a kind of like candidate obligation. When we're not analyzing like the candidate's obligation, we're taking the candidate as given and assessing your obligation given a candidate. And so always be aware, I think, of that terminology. She deserved to lose. She didn't deserve my vote. I didn't owe her my vote. You don't owe anyone your vote. That is what I take to be kind of like weasel language, whether intentional or not. The second part here, and it's something that Joanna and I have discussed, where she's been super influential on my thinking here, because she's writing a piece on genocide and we've had conversations about it, which is this kind of like totalizing view of genocide. And this is going to sound perhaps a little bit callous, but I don't mean it as such. I actually think it's a really important point. I tried to bring it up in the conversation. I don't know if it was lost, but, and again, I don't want it to sound callous. Genocide is not the only thing that matters. Genocide doesn't even necessarily require anyone to die by its strict legal interpretation. There are genocides in history that have been less harmful than other things in history. Thank you very much for the super chat. Jay Ray says, Prime is way too much of an ideologue. He should be able to accept that damage reduction is important to all the causes we left support allegedly. Deontological versus utilitarian. I'm some kind of like rule utilitarian or a threshold deontologist or something like that. I'm not a moral realist. Again, to the extent that I understand these terms, I don't truly have a strong comprehension of the philosophical underpinnings of everything that I'm saying right now, and I don't have a learned history of the important, texts on these areas. So this is just me navigating an area that I admit I'm not super well read on. But that's, as I understand those terms, maybe the best way to approximate what I think. Okay. What was I saying? Shit. Editor. Recut here. Genocide is not the only thing that matters. There are other evils and harms that need to be weighed. Like, I don't know why your rule would be prevent genocide or vote against genocide, even if the vote, if actuated, wouldn't save you against the genocide, and even if there are other massive amounts of social ills that will come about by your actualizing the preferred outcome. And what I mean is, like, how do you weigh the genocide of the Gazan people against millions of deaths of starvation elsewhere, which are not genocide, or millions of deaths due to disease? It's not intuitive to me that the only thing that we should care about, to the exclusion of other things, is death by genocide. Not to say that we shouldn't consider and weigh actual or supposed support for a genocide in our voting calculus. Of course we should. That's why, by the way, I would vote for Kamala. If anything, I think the genocide and what's happened in Gaza is more of a reason to support Kamala and not Trump. But even putting aside, like, why is it that you're a single issue voter on genocide? You shouldn't be a single issue voter on genocide. there are war crimes that are not genocide, that are horrible and sometimes even worse than a genocide. Ben Riley, thank you for the super chat. Thoughts on a liquid democracy versus our current one? I don't know what's meant by liquid democracy, but thank you for your super chat. Right? There's arguably certain war crimes or crimes against humanity that, taken in their totality, regardless of whether there's that intent, the genocidal intent, you would consider worse than a genocide in a given context. So I do think sometimes genocide bad, 100%. You should work to prevent genocide, no doubt. But it cannot be the only thing that you're factoring into your analysis. You cannot be a single issue voter on genocide. It is not the morally, in my opinion, what I take to be the ethically correct thing to do, is to vote on account of genocide and nothing else. That said, if you were only voting for a genocide or on the basis of perceptions regarding a genocide, obviously the vote is for Kamala. And I think it's the most revealing question I posed to him was, given the choice between voting for Kamala and saving the lives of 20,000 Gazans, what would you choose? And he would say, I'm going to repeat that one more time. Editor cut. I think the most revealing situation and question that I asked Prime was when I asked him, choose between not voting for Kamala and 20,000 Gazan children dying, in voting for Kamala and 20,000 Gazans surviving. And he chose not voting for Kamala, even when there was 20,000 lives at stake. That is a level of deontological commitment that I truly can't understand. Like, the thought of 20,000 lives being saved by your vote, and on the basis of your virtue signal, you wouldn't save those people. I mean, that to me is insane. And it's also counterintuitive to any kind of peace strategy, right? By that logic, why would we ever make peace between Israel and Palestinians? Presumably, any peace that's achieved would have to kind of like give both sides something, right? Some kind of mutual understanding, or where there would be some kind of concessions made to a genocidal state, right? In Prime's eyes. Super chat from Ian. They don't mean genocide as a legal definition. It's an emotive thing for the worst thing they can imagine. It just means worst thing ever. I think that might be a salient comment there, but I'm just saying, like, even the prospect of peace, achieving a peace, necessitates some amount of, in this context, compliance, acquiescence with a state that is responsible for a genocide. And so, by that logic, like, why would voting and settling a position that way be some kind of like exceptional act which wouldn't be encompassed by negotiations between the relevant parties? Do you understand what I'm saying? So, like, you're willing to say, I take this pure stance when it comes to voting, but given the choice to Prime, like, let's say that you're the President Prime, and you're saying, listen, you can end the genocide right now, you can get peace right now. What you're going to have to do, though, is you're going to have to cede some land over to Israel. Or you're going to have to, we'll even get a two-state solution, end the genocide, but there just has to be mass amnesty for everyone involved in Israel, right? And I think, given the deal, a final settlement of final status issues, ending the genocide, saving the lives of the Palestinians, but full amnesty for any Israeli war criminal, I would take that deal. I think if you cared about the Palestinian people, you would take that deal. I understand it's not a true choice. I'm not saying that this is the actual choice that presents us. I'm saying, imagine this were the choice. And I don't think you can call yourself a friend to the Palestinian people, especially when a lot of these deals are being proposed by the Palestinians themselves. Even Hamas, right? Hamas is offering deals. Well, you would never say, well, I don't make compromises on genocide. I couldn't make a compromise on a genocide. Of course you would have to make one in the context of negotiations. So why is there this kind of like vote exceptionalism where we have to be maximally pure with respect to voting, but can be decidedly less pure when it comes to imagined negotiations, imagined deals? Voting should be considered, and the election of a person to lead an effort should be considered part of that whole calculus. And absolutism with respect to voting, I think, is doesn't make sense. Why you would treat voting from everything else. So those are some musings on that portion of the discussion. On the actual napkin math, listen, I have seen some critiques of the polling done by this firm in conjunction with YouGov. I've seen that. I'm not going to tell you right now that I've spent a ton of time internalizing all those arguments. To me, it seemed like applying some napkin math to, incorporate the amount of lost vote from 2020, which had much more people voting than 2024, in a way to like capture that lost vote and make the argument that different positions on Gaza would have changed that. But I think it just doesn't contend with the basic counter argument, which is you don't view the position on Gaza in isolation. You view the position on Gaza not just for what you could have gained, but what you could have lost. What you could have lost in terms of ideological pro-Israel people in the context of pre-November, right? And pre-Trump administration, now where the popular support has, I think, shifted way more to the Palestinians. Thank you. But also what you could have lost in terms of looking like you're a disorganized mess, chaotic mess, criticizing your own president as like a genocide warmonger. That could have lost votes too. And so fundamentally, regardless of the methodology here, which I'm not going to pretend that I'm a statistician, though I did take a statistics class in my economics degree. I think that there's you're not considering what you could have lost. You can't just consider what you are likely to gain. And then I'm not sure that he's accounting for the difference in population, the difference in where the vote is taking place. So yeah, that's my response on the numbers analysis there. Super chat Poole saying he didn't care about the law but appealed to it for the rest of the debate. Yeah, that's one. I did throw that at him one time where I said, like, why do you care about the law vis-a-vis the Second Amendment but not any other law, right? You care about this law. And then I think I even got him to say, well, I only say that it's illegal as a kind of bad faith maneuvering. I think he even admitted that I'm only saying it's illegal even though I don't really care if it's legal or not, as a polemicist, which is kind of weird. Anyway, back to Prime. Other final thoughts on the Prime conversation. I don't know what I could do to reach someone like Prime on this issue. He strikes me as someone, if I'm being honest, who's not interested in being convinced. And having taken that hard of a line, I don't know what it would take to move him off of it. I think that's going to have to be a natural little thing that happens. But yeah. Any questions? Yeah, Josiah, I think I could have done that better as well. Oh, last thing on the Prime thing, and then I'll take your questions. The whole like shit lib thing. You're a shit lib. You're a shit lib. I don't really care. I don't like to get into the whole like, you called me this name, and so I'm gonna like, I don't really give a shit. I take that as all part of the game. Remember when I called that guy a bitch? That tiny guy? Apparently he showed up to the Tim Pool thing. I didn't see him. Like, whatever. And I think focusing on the insults during the conversation, one, I'm never apt to do that. Unless there's a specific meta conversation we're having. Cut. Unless there's a specific meta conversation we're having, I'm not apt to focus on that. I think it kind of looks like a bit petty. Why does it irk you so much that he drew a hard moral line at genocide? So, again, well, a couple things. One is, if there is a significant material difference in the candidates with respect to that same genocide, I think that's, just an issue I'm having with his deontological perspective there. Second, I don't think that my hard line is, if there is a significant massive difference, right? A significant massive difference. I guess those are maybe oxymoronic in this context. If there is a humongous, immense gulf between one candidate and the other, then regardless of if they're a criminal, regardless of if it's really going to affect the lives of people in a massive, demonstrable way, then the hard line is you vote for less harm. And so I do have, in principle, a problem with that deontological line, where I can understand a threshold for voting in the absence of a massive gulf between the two candidates that doesn't affect people's lives in a massive, humongous way, right? So I can understand saying, I will not vote for, a sex offender, a murderer, a genocide supporter, given that the two candidates are very similar. I can understand that as a threshold. But when there's a massive, demonstrable difference between the two candidates, it's going to affect people's lives in huge, demonstrable ways, then I don't understand it. So I do have a problem with drawing any line in the context of a massive, huge gulf like that. So you're right about that. And that is any line. That's even the most gross lines that you can come up with. And I might be calling for that person to be voted in and then immediately impeached, for example. I might be calling for that person to be voted in and then have them be disqualified some way, right? But yes, if it's going to be a massive, huge gulf between the two candidates in a demonstrable way, yes, I have a problem with drawing a line anywhere. Separate from that, right, is this kind of analytical line where we only consider the harm of genocide to the exclusion of other harms. So you have one candidate is like, all right, you're pro-genocide, and the other candidate is pro, not genocide, just like a pro-mass, starvation on orders of magnitude worse. Right? Like, you're in favor of not genocide, but just killing the entire human race through starvation. It's not clear to me that the preference there would be for the mass starvation person. And having an analysis that has the genocide exceptionality to the exclusion of war crimes and crimes against humanity. Again, I'm not saying you don't consider that and war crimes and crimes against humanity. And I'm assuming most pro-Palestinian people are going to consider both genocide, crimes against humanity, and war crimes. And genocide. So I'm not saying that most pro-Palestinian people only consider genocide. I'm saying considering only genocide, if you were to do that, and discounting the other harms such as mass starvation, mass disease, war crimes, crimes against humanity, institutional structures in your own country, the ability for you to help other people in the future because now you live under a fascist tyranny. That only focusing on genocide is myopic. And I think it's kind of like emblematic of a moral confusion here. Oh, that's another thing I wanted to bring up. Great point, Firebomb. This whole like, well, my vote didn't matter. That's another, I think, slippery thing that people will say. Yes, in isolation, everyone's vote didn't matter. But we understand fundamentally what we're asking when we say who you should have voted for. We're talking about like the demonstrative signal, right? The signal value of your vote and what it says about your preferred outcome, right? So we're not really, when we say it was wrong for you to vote for Trump, we're not saying it's wrong because you could have affected the outcome. We're saying it's wrong because your expressed preference or lack of preference is the bad signaling value or demonstrates a lack of or is unethical in terms of if it were actualized. So the question about it was wrong to vote for Trump, it was wrong to vote for Kamala, is not a question about the instrumental effects of your vote. It's not a question of did your vote actually change the outcome. It's about getting in the head of that other person if their preference were to be actualized and what their vote has to say about the signaling value or the internal value that one obtains from that vote. It's the other theories of vote value. And so getting bogged down in the whole like, well, my vote wouldn't have changed anything, it's kind of missing the point of the conversation. Yeah, granted, anyone's individual vote doesn't change the outcome. That's not what we're talking about here. What we're talking about here is the actualized outcome entailed by your preference, if you could choose, and the associated values there. I hope that makes sense. That any kind of retreat to, I didn't change anything. Anyone could say that about any vote all the time. And so you voted for this person, it was wrong to do. It's a kind of shorthand for that other stuff, which is your express preference. I hate that you let Tim Pool frame the debate when he said Dems bulldoze homes. Why not ask for data? Because I don't want to get bogged down in the actual discussion. So this is a good question. I'm not mad at you, Set. I don't want to get bogged down in an actual conversation about the bulldozing homes. That's what he wants. Like, I just want to be like, I don't know, like, fine. Like, yeah, I would say this wrong. Can we just talk about what we're here to talk about? So in the moment, right, it's like me playing fisticuffs with ghosts. And for all I know, he's like properly representing the thing. So why would I take a battle on his ground where it's fertile and where he maybe has access to more of the facts and where I'm having to like look up and scramble in real time. And then that leads to me potentially making more mistakes. I will read Kick Chat, by the way. That leads potentially to me making more mistakes by saying, oh, here it says this. And then he goes, oh, no, you see, you fell for it. So I understand the frustration, but he's always going to pull something esoteric, right, out of his backpack. And I think the best thing you can do is be like, that's not relevant to our discussion, dude. Assuming that you're telling the truth, I don't think it has anything to do with what we're here to talk about. And it's not a diffusion of responsibility, right? Because how would I have prepared for this specific Chicago example? And to say that I'm diffusing responsibility or that I'm like not doing something responsible here, it's to suggest either I should have prepared for it or that it would have been preferable in that moment, other than to talk about like the deployment, which I'm prepared to talk about and where I feel like I'm very strong, to like start actually hashing out this thing I don't know about in real time, where obviously he wants to talk about this, right? It's an obvious bait to get me to be like, that's not true. The Democrats don't ever do anything bad. So again, you can disagree. I don't know that it's the optimal strategy to get dragged into a conversation that I'm not prepared to have. And I don't think it's irresponsible for me not to have prepared for that conversation, because it's always going to be one thing or the other, right? Do you guys agree or disagree? Please let me know. I can't believe you didn't prepare for Tim Pool's 3,000th random anecdote. And that was what I was trying to do, was debate him into saying that's just an anecdote when I brought up the whole, I was a bartender and everyone I talked to, and I know that's not an argument, but I'm just trying to show the audience that when he brought it out, I said, that's just an anecdote, dude. I think it's demonstrative of the way in which he argues. And it shows the kind of like ridiculous premise of what he's saying, which is essentially that we should change our mind on some disparate policy based on like someone he talked to or his neighborhood or whatever. I think you should have just said, I don't believe you, and hand waved it. Yeah, maybe from now on I could be like, listen, I don't know what you're talking about. I don't believe you, but whatever. Let's move on. If you don't know the facts, it's better to not engage. Right, like I don't want to. If he were to bring up, let's say I had no understanding of a particular, it's one of the reasons why debating anti-vaxxers, if you're not prepared, I think can be harmful. But one way to get around it is just be like, listen, you're wrong about this. I know you're wrong. Right now, I don't want to have a conversation. We're not here to have an anti-vax conversation. Because they've prepared some example. Don't you know that in 1942, the whatever vaccine did whatever to this one person here, and this one founder of this vaccine said that they're always unsafe to do this kind of like, and even the most like experienced vaccine debater, misinformation or whatever, can't reasonably prepare for every like anecdote or bullshit thing, right? It's a lot harder to swat down in real time. And it was also true, by the way, of the election fraud stuff. And even me, I read a lot about these election fraud cases. I went into the weeds here in terms of the evidence that was being brought. And sometimes someone would bring up something I hadn't heard of. 99% of the time it was bullshit, but like doesn't mean in real time. Sometimes I would indulge them and be like, let's look this up in real time. But it was hours and hours on like one thing, right? And in the context of a Tim Pool debate, where I'm already 3v1'd, I don't know that it's the best look for me to try to drill down on that one point. It's kind of why I resisted the urge to go on the presuppositional debate with the religious guy. One, because I think I had a mission to talk about the deployment. And two, because that's kind of a debate he wants to have, even though I kind of wanted to have it too, because I like that debate. He's much more comfortable in there, right? And even though I have a curiosity for this, it would be a diversion, right? And it's his fertile ground. Couldn't you expose your lack of understanding with questions? I mean, I could, but then I'm just like asking questions that they can maybe provide an answer to. Like, is this true? Was it the Democrats? Did they have some other purpose there? And they can be like, nope, they didn't have a purpose. Like, I don't have any. When I ask questions, oftentimes, not always, I'll have in my mind, like, this is where I'm going, right? So, for example, with like Prime, I might have a set of questions where in my head, roughly, I'm going in a particular direction. I'm not always doing that, by the way. So I don't want people to think that I'm always like precogging what they're trying to say and I'm always have this dialogue tree. That's not always what I do. I do listen to people. But I think when you're just kind of shooting in the dark, it's a little bit more tough to like hatch out a strategy. And at that point, you're on a big platform, right? And if you're just asking questions that aren't making them sweat, where I can make them sweat with like, would you support if it's illegal? So you're saying whatever. That I think is much more fruitful for me to dedicate my time. I have to say, maybe it's all psychological, but this air purifier is making me feel better. Okay, cool. Going tit for tat with data is a bad strategy, in my opinion. I think you should expose their lack of understanding. I mean, I try to. You let me know if I don't do a good enough job. Any questions? Anybody want to call in for a second? If not, even though I'm feeling a little bit better, I'm feeling kind of hoarse. Do you think that the 10 federal judges that anonymously spoke to NBC violated the code of conduct for U.S. judges, canons 2 and 4? I don't know, but I'll think about it. All right, folks. Not seeing anything. I'm going to go recover. I'm going to let the air purifier do its job and purify my air. Hopefully I'll feel better. I'm going to check for I'm going to check for like black mold or whatever you guys are saying. Maybe there is, who knows? Or maybe I'm just sick. But we'll be back at 7 for Live and Learn. Yeah. I love you all very much. Remember to like, comment, and subscribe. It means the world. I lost a bunch of subs in some of the recent like critical self-critique stuff, but it's really nice to see the numbers doing well because you guys seem to enjoy the content, and yeah, it means the world to me that you guys continue to tune in, and can't wait to see you later tonight. Peace out.